Hi, I'm Paul Peterson.
I'm Chris Sun Liu. This is part 2 of our lecture on modern federalism, where we'll be discussing the spending clause. Professor Peterson, spending power is the second important power we're talking about after the Commerce Clause. What does the Constitution say about the Congress's power to spend?
Well, in the Constitution, it is written that Congress shall have the power to lay and collect taxes to provide for the general welfare. So it doesn't actually talk about spending, but it's implied in this phrase that Congress does have that power to collect taxes to provide for the general welfare. But the question arises, what does the general welfare mean?
That's a good point. The general welfare could be potentially ambiguous. What was the major Supreme Court case surrounding this term?
Well, for a long time, this phrase was never defined. But in the 1930s, the Social Security law was passed. The Social Security law provides for the retirement of people over the age of 62 and over the age of 65. It also provides for medical services through the Medicare program, which was passed in 1965. So this is a pretty important piece of legislation. And the question arose as to whether or not it was constitutional. And the law was passed in the middle of the Roosevelt administration when you had a conservative Supreme Court that was declaring many of the laws of the New Deal, that is Roosevelt's social policies, unconstitutional. So everybody wondered whether or not the Supreme Court would declare Social Security unconstitutional as well. In Helvering v. Davis, a case heard in 1937, it was another instance of the switch in time that saved nine. It was one of those key decisions where the court found that the New Deal legislation was in fact constitutional. Well, the argument against the Social Security was that the spending was just for old people. It wasn't for the general welfare. It wasn't for everybody. You had to be a certain age in order to get your Social Security benefits. So therefore, you couldn't spend money for this purpose. That was the case that was made by the plaintiffs, and they won on that case in the lower courts. But Justice Cardozo, when he listened to the arguments, decided, along with a majority of the court, that making a decision as to what is the general welfare and what is not the general welfare is too complicated for the courts to get into. The discretion belongs to Congress unless the choice is clearly wrong, he wrote. So that's a really interesting decision by the Supreme Court with respect to the spending clause. It has come very close to saying we are not going to do judicial review of spending. Congress can spend money on anything it wants. Well, they kept a little face saver in there by saying unless clearly wrong. But they made the decision that Congress is going to make the decisions on spending, not the Supreme Court.
The story on spending develops further in another case around 50 years later, South Dakota v. Dole. What were the facts of this case?
Well, in this case, Congress passes a spending bill which gives a federal grant to state governments, which they can use for the roads in their states. But they include in this law a provision that says that people cannot drink until they reach the age of 21. Well, South Dakota is a place where the art of drinking was acquired at an earlier age than 21. I know that because I grew up 40 miles from the South Dakota border, and we discovered in my adolescence that life was better on the other side of the border. So South Dakotans fought this particular piece of federal legislation. They said, we want that federal money for our roads, but we don't want to give up our drinking age of 18. So why are you telling us to do that? The drinking age has nothing to do with transportation. Well, the other side of the argument was that people who are at the age of 18 are more likely to have an accident, and they don't have the good discipline that their elders have not to drink and drive at the same time, so it all made sense. Well, the Supreme Court didn't get into that in all great detail, but it did decide that the federal government isn't really ordering the states to do anything. It's just saying, okay, we're going to give you this money, but there's going to be some terms associated with it, some regulations attached to it. And if you don't want the regulations, well, then you just don't get the money. Now, what's really interesting about South Dakota v. Dole is that this is not just about drinking. This is about any piece of federal regulation. So now the federal government can not only spend money, but they can tell states you don't get the money unless you do as you're told. So that's a huge expansion of federal power.
Professor Peterson, to conclude this part, let's go back to the Sebelius case that we talked about at the end of last part. We know that Congress cannot regulate inactivity, but can it levy a tax? And can it tell states what to do by conditioning on a grant?
Well, yes, it can levy a tax, and that's how they saved Obamacare or the Affordable Care Act. That's how they decided that it was, in fact, constitutional, Chris. But there was another aspect of the case that they found unconstitutional. So the main features of the law were declared constitutional under the tax and spending clause of the Constitution. But the regulatory provisions where they gave money to the states based upon the fact that there was going to be a large sum of money coming to each state to help pay for the Medicaid provisions of the Affordable Care Act, the issue came up as to whether or not this money was such an enormous sum of money that the federal government was now ordering the states what to do, even though South Dakota v. Dole had said the federal government can attach any regulation to a grant and aid. Well, the Supreme Court said no this time. So we get a qualification of South Dakota v. Dole. It's no longer the case that the federal government can attach any regulation to any spending bill. If the spending is a very large sum of money, they got to be careful about the regulations they attach to it.
So, what do we conclude about the power of the national government over the state governments?
Well, Chris, I think we can say that the Commerce Clause has some limits. For example, it cannot regulate inactivity. It cannot regulate the use of guns on school property. That's something for the states to do. We found that in the Lopez case. But it is a fact that the power to tax and spend is just about unlimited. And you can attach a lot of regulations to that, but you can't go overboard, as was the case in Obamacare, where they gave a lot of money to the states and then packed on a lot of regulations. That was interpreted as too much of the federal government ordering the states around. So we have now some limits on the tax, spending, and regulatory powers of the federal government.
Now that we've discussed the Commerce Clause and the Spending Clause, we're ready to dive into how federalism works in practice today in Part 3 of our lecture of Modern Federalism.